Okay, so today we are going camera free because I forgot I actually moved my camera to the TV because we did a convention yesterday. So today we're going to talk about the evolution of personal jurisdiction. My name is Devaney Wilmot, and welcome to Legally Noiret or Legally Raven Haired, where we do the law from a person who has black hair. Okay, so we're going to talk about an introduction to personal jurisdiction. We're going to talk about Pennoyer V Neff, and the doctrine of rigidity and a lot of fun stuff this morning. So let's go ahead and get started and we will see how much we can get done. All righty, just move into a screen that's a little easier for me to view. So an introduction to personal jurisdiction. In previous chapters, you learned that a fundamental procedural requirement, a court must have subject matter jurisdiction over a case. The present chapter and the 3 chapters that follow it explore an additional requirement. A court must have the authority to require the defendant to appear in the forum and defend the action there. This judicial authority is referred to as personal jurisdiction. So, additional requirement, the court must have authority, all right, to require the defendant to appear in the forum. All right, let's highlight that. To illustrate how personal jurisdiction differs from subject matter jurisdiction, consider a simple example. Imagine that Peter, a Massachusetts citizen, takes a vacation in Alaska and is in a car accident there with Dahlia, an Alaska citizen. Peter suffers injuries in the accident, so after returning home to Massachusetts, Peter asks his lawyer to sue Dahlia in Massachusetts state court, okay, because that's where Peter lives. That's where he wants to sue Dahlia. As we have learned, subject matter jurisdiction is not a problem in that court. State trial courts have broad power to hear the most types of cases, including most tort claims. A lawyer simply needs to determine which Massachusetts state trial court has subject matter jurisdiction, the superior court, the district court, not whether the Massachusetts state court can hear the case. So here we go. They have subject matter jurisdiction. So state trial courts have broad power to hear most type of cases, including most tort claims. All right, let's get that. Great. But because there is a Massachusetts state court with subject matter jurisdiction over this type of dispute, so subject matter jurisdiction is the type of dispute, does not mean that the court has power to force Dahlia to defend the case in Massachusetts. Looking at the case from Dahlia's perspective, she lives in Alaska. She drove her car in Alaska, was involved in an accident in Alaska. So why in the world would Dahlia think that she's going to go into court in Massachusetts? She would consider it grossly, not just unfair, but grossly unfair to have to defend a case all the way in Massachusetts. What is the distance from Alaska to Massachusetts? How long to drive from Anchorage to Boston? Let's just see. 75 hours in a car. Okay. And then let's look at plane tickets. Plane tickets from Anchorage to Boston. And I've been to Alaska. It was beautiful. So we're looking anywhere from $300 to $969 round trip. Okay, we're looking at the end of April to beginning of May. So we can see that would be grossly unfair, right? So now she didn't, and now if it had happened in Massachusetts, that would be different, but it didn't. Dahlia would be right. Given the facts of this particular case, the Massachusetts court does not have the power to exercise personal jurisdiction over Dahlia, even though the court might have subject matter jurisdiction over the lawsuit. As this chapter explains, the United States Constitution imposes important restrictions on a court's authority over defendants. Specifically, the 14th Amendment provides that a state may not deprive a person of property without due process of law. Because entering and enforcing a civil judgment can result in a defendant's loss of property, for example, money damages, a court must use fair procedure, due process before entering that judgment. Okay. And one element of procedural fairness is ensuring that the court has the appropriate relationship to the claims or the party. So the claims, that is the type, and the parties, those are the people. Here, since neither the claim nor Dahlia has any connection to Massachusetts, Dahlia would not be deprived of due process of law if the Massachusetts court asserts jurisdiction over her. So if the accident had occurred in Massachusetts, then they would have the appropriate relationship to the claim, or if Dahlia lived in Massachusetts, then she would. So even though the plaintiff in this case, what is his name? I forget, Peter. They have jurisdiction over Peter, but not over Dahlia. So unfortunately, the 14th Unfortunately, the 14th Amendment due process clause speaks only in general terms. It does not explain when a court can require um, an out-of-state defendant to appear to defend an action in the state. As a result, judges and generations of law students have struggled to understand what due process means. So it's a struggle to understand due process in the personal jurisdiction context. The case and materials that follow explain what the courts have found. The cases not only reveal how courts have interpreted due process, but they also illustrate a fascinating feature of the law. More generally, it evolves continuously to reflect changes in society. So, it's a moving target. It is a moving target. These materials explain why that evolution has taken place and how it has led to the current principles that limit a court's exercise of personal jurisdiction. So now we see that it's called the evolution because it's a moving target. It continuously changes. Early history, Pennoyer v. Neff. Pennoyer v. Neff is an early and important case in which the United States Supreme Court tries to define the appropriate limits of a court's power to exercise personal jurisdiction over out-of-state defendants. Some aspects of Pennoyer are no longer good law. They have been superseded by subsequent cases. Nonetheless, Pennoyer's basic premise about a court's authority to exercise personal jurisdiction prevailed for nearly 70 years, and in some respects still do. Pennoyer procedural history. The Pennoyer opinion is difficult to follow in part because it describes two related lawsuits. The first one filed, so let's highlight the first one. The first one filed in 1865, J.H. Mitchell sued Marcus Neff in an Oregon civil court, a state trial court level, alleging that Neff owed Mitchell legal fees. Mitchell could not locate Neff, so pursuant to an Oregon statute, Mitchell tried to notify Neff of the suit by publishing a notice several consecutive weeks in a local newspaper. Despite the notice, Neff did not appear in court. As a result, the Oregon State Court entered a default judgment, a judgment for failing to contest the action in favor of Mitchell. So Mitchell won because Neff never showed up. Mitchell subsequently used that default judgment to obtain a writ of execution in order that allowed the sheriff to auction off land owned by Neff in Oregon. Okay, so here we go, to satisfy the civil judgment. Mitchell himself had purchased the land at auction, which was given a share of seed of the land and sold the land for a tidy proffer to Sylvester Pennoyer. So here we go. We have this case. Mitchell sued Marcus Neff in the Oregon Circuit Court. Mitchell did not know where Neff was, so he just posted, publishing a notice for several consecutive weeks. Neff did not appear in court, probably because he never saw the notices, because I believe he didn't live in Oregon. And then the court gave Mitchell a default judgment. Right, so Mitchell used this to get a writ of execution that allowed him to auction off land owned in Oregon to satisfy the civil judgment. Mitchell himself purchased the land at the auction and was given a share of seed to the land, and then he made a tidy profit to Pennoyer. Several years later, Neff returned to Oregon and discovered that Pennoyer occupying his land. Uh-oh, this is like Goldilocks and the Three Bears, right? Neff gets there, and Pennoyer is like, hey, I'm on your land and it's just right, and I ate your porridge. So Neff responded in 1874. So we have 9 years later. Here is lawsuit number 2. All right. Neff responded in 1874 by filing a lawsuit against Pennoyer in federal court. So now we have the federal court because they live in two different places, which is what we know now, claiming that Pennoyer had not acquired a good title to the land and that the land should be returned to Neff. Among other arguments, Neff contended that the original judgment, Mitchell v. Neff, and the subsequent sheriff sale of the land were invalid because the state court never acquired jurisdiction over Neff or his property. For this reason, Neff argued that he still owned the land. The federal court ruled in Neff's favor, and Pennoyer appealed to the Supreme Court, whose opinion appears below. Keep in mind, the opinion deals with Pennoyer's appeal in the second case and not the earlier dispute between Mitchell and Neff. All right, so terminology. A further bit of useful background involves the distinction between personal jurisdiction and jurisdiction in personam and in rem jurisdiction. So we need to understand. A court has personam jurisdiction over a defendant if the court has the authority to acquire the defendant to appear personally and defend the case in a state where the suit was brought. If a court has this type of jurisdiction over a person, a judgment against the defendant can be satisfied from any assets the defendant owns. All right, so if a court has this type of jurisdiction, Judgment against the defendant can be satisfied from any of the assets that the defendant owns. So I guess it doesn't matter what state those assets in. In contrast, REM jurisdiction involves a court's assertion of control over a defendant's specific property, such as real estate or a bank account that is located within the state where the defendant is sued. Okay, so they have jurisdiction over this item, this asset. Historically, courts frequently asserted REM jurisdiction over defendant's assets, even if the defendant herself was not subject to personal jurisdiction in the state. The defendant was not required to appear personally. In these type of cases, the court would issue a writ of attachment ordering the sheriff to attach, assert control over particular real personal property that the defendant owned in the forum. All right. Unlike personal jurisdiction, in REM jurisdiction did not give the court jurisdiction over the defendant personally, but it did subject the defendant's attached property to the power of the court. So you own the property, but not the person. Okay, the property, but not the person. If the court subsequently upheld the plaintiff's claim, the court could order the attached property sold to satisfy the claim. However, unlike a judgment based on in-person jurisdiction and in REM jurisdiction did not subject the defendant to orders from the court or entitle the plaintiff to collect the judgment from other properties the defendant owns. So the court only has control over this particular property in this state. So if you own something in a different state or a different piece of property that the court has not asserted control over, then they cannot attach that property or satisfy a judgment using that property. Not surprisingly, plaintiffs prefer to establish in-person jurisdiction over a defendant, and that makes sense because then personal jurisdiction may be satisfied out of any of the defendant's assets, not just the assets attached pursuant to the court's in REM jurisdiction. So, hey, it's a bigger piggy bank, basically, deeper pockets. In addition, because of the full faith and credit clause in the Constitution requires state courts to recognize impersonal judgments of another. Okay. In addition, because the full faith and credit clause, all right, full faith and credit clause in the Constitution requires state courts to recognize in-person judgments of another state's courts. The plaintiff can take an in-person judgment to another state in which the defendant has assets and enforce the judgment there. And in REM judgment, by contrast, only authorizes the sale of a particular property that the court is attached, and the judgment cannot be enforced in other states under the full faith credit. Okay, so if it is impersonal judgments of another, the plaintiff can take the judgment to another state where the defendant has assets and enforce it there. All right, money, money, money. So make it green. But in this one, they can't do that. Reading Pennoyer V Neff. As you read Pennoyer, consider the following questions. According to Pennoyer, when can a court exercise a person jurisdiction over a defendant? When can a court exercise in REM jurisdiction? Which form of jurisdiction was at issue in the case? And what does the court conclude that why does the court conclude that the state trial court that ordered the sale of Neff's land lacked jurisdiction to do so? So let's do this here. So we're going to copy this. When can a court exercise in-person jurisdiction over a defendant? All right, so let's look. Anything about this is going to be in yellow. Okay, we're going to make this yellow. Okay, let's see. Mr. Justice File delivered the opinion to the court. This is an action to recover the possession of a tract of land of the alleged, of the alleged value of $15,000 situated in the state of Oregon. The defendant, Pennoyer, claims to have acquired the premises under sheriff's deed made upon the sale of the property on execution issued upon a judgment recovered against the plaintiff in one of the circuit courts of the state. The case turns upon the validity of the judgment. It appears that from the record that the judgment was rendered on February 1866 in favor of J.H. Millen for less than $300, including costs, and an action brought by him upon a demand for services as an attorney, that at the time the action was commenced and the judgment rendered, the defendant therein, the plaintiff here, was a non-resident of the state, that he was not personally served with process and did not appear therein, and the judgment was entered upon his default in not answering the complaint upon a constructive service of summons by publication in a local weekly newspaper in Oregon for 6 consecutive weeks. So here's the issue here. Okay, let's see. The defendant was a non-resident of the state. Okay, so that would mean he does not have personal jurisdiction. He was not personally served with the process, because if you serve somebody with process in the state, you can also gain jurisdiction that way. Did not appear therein, and the judgment was entered upon default of not answering the complaint under constructive service of summons by publication in the local weekly newspaper in Oregon for 6 consecutive weeks. But the problem is he didn't live in Oregon. So, I mean, hello, how was he supposed to read that? The authority over every tribunal is necessarily restricted to the territorial limits of the state in which it is established. Any attempt to exercise authority beyond those limits would be deemed in every other forum, as has been said by the court, an illegitimate assumption of power and be resisted as mere abuse. In the case against the plaintiff, the property hearing controversy served under the judgment rendered was not attached. Okay, so if it wasn't attached, then that means this is about in rem jurisdiction. So let's make this green. What can a court, when can a court exercise in rem jurisdiction? All right. When can a court exercise in rem jurisdiction? Okay, so it's like in this case, against the property hearing controversy under the judgment rendered was not attached nor in any way brought under the jurisdiction of the court. Its first connection with the case was caused by a levy of its execution. It was therefore disposed of. It was not therefore disposed of pursuant to any adjudication, but only enforcement of a personal judgment having no relation to the property rendered against a non-resident without service of process upon him in the action or his appearance therein. The court below did not consider that an attachment of the property was essential to its jurisdiction or the validity of the sale, but held that the judgment was invalid from defects in the affidavit upon which the order of publication was obtained and the affidavit by which the publication was proved. Okay. The court concluded that Neff should have raised the affidavit. The court concluded that Neff should have raised the affidavit's defects in the state trial court or by appealing to the state court's decision, but Neff failed to do so. The court concluded that the defects could not be raised in a federal court proceeding. Thus, the only argument that was properly before the court concerned personal jurisdiction. The court concluded that Neff should have raised the affidavit's defects in the state trial court or by appealing the state court's decision, but Neff failed to do so. The court concluded that the defects could not be raised in the federal court proceeding. Thus, the only argument was properly before the court concerned personal jurisdiction. But it also contended in that court, and is insisted upon here, that the judgment in the state court against the plaintiff was void for want of personal service of process on him or of his appearance in the action in which it was rendered, and that the premises in controversy could not be subjected to the payment of the demand of a resident creditor except by proceeding in rem, that is, by a direct proceeding against the property for that purpose. If these positions are sound, the ruling of the circuit court, okay, let's see. At the time of Pennoyer, the circuit court functioned as a federal trial level court. The first paragraph of the opinion also refers to circuit courts, but the reference there is to the trial level state courts of Oregon. Just be aware of the term circuit court has two different meanings. All right, so let's go back. Okay. If these positions are sound, the ruling of the circuit court as to the invalidity of the judgment must be sustained. notwithstanding our dissent from the reasons upon which it was made, and that they are sound would seem to follow from two well-established principles of public law respecting the jurisdiction of an independent state over persons and property. The several states of the Union are not, it is true, in every respect independent, many of the rights and powers which originally belonged to them being now vested in the government created by the Constitution, but except as restrained and limited by that instrument, they possess and exercise the authority of dependent states, and the principles of public law to which we have referred are applicable to them. One of these principles is that every state possesses exclusive jurisdiction and sovereignty over persons and properties within its territory. As a consequence, every state has the power to determine for itself the civil statutes and capacity of its inhabitants, to prescribe the subjects on which they may contract, the forms and solemnities with which their contracts shall be executed, the rights and obligations arising from them, and the mode in which their validity shall be determined and their obligations enforced, and also to regulate the manner and conditions upon which property situated within such territory but personal realm may be acquired, enjoyed, and transferred. The other principle of public law referred to follows from the one mentioned, that is, that no state can exercise direct jurisdiction and authority over persons or property without its territory. Story. Conflict law C2, the several states are of equal dignity and authority, and the independence of one implies the exclusion of power from all others. And so it is laid down by jurists as an elementary principle that the laws of one state have no operation outside of its territory except so far as it is allowed by comity, and that no tribunal established by it can extend its process beyond its territory so as to subject either person or property to its decisions. Any exertion of authority of this sort beyond this limit, says Story, is a mere nullity and incapable of binding such persons or property in any other tribunal. But as contracts are made in one state may be enforceable only in another state, and property may be held by non-residents, the exercise of jurisdiction which every state is admitted to process over persons and property within its own territory will often affect persons and properties without it. So the state, through its tribunals, may subject property situated within its limits owned by non-residents to the payment and demand of its own citizens against them. And the exercise of this jurisdiction is in no respect infringes upon the sovereignty of the state where the owners are domiciled. Every state owes protection to its citizens, and when non-residents deal with them, it is a legitimate and just exercise of authority to hold that to hold and appropriate any property owned by such non-residents to satisfy the claims of its citizens. It is in virtue of the state's jurisdiction over the property of a non-resident situated within its limits that its tribunals can inquire into that non-resident's obligations to its citizens, and the inquiry can be carried. One second. Okay, it's recording still. I don't know what it means. If the non-residents have no property in the state, there is nothing upon which the tribunals can adjudicate. So Neff had property in the state, but they didn't attach the property. So they could have had in rem, but they tried in personam, and that became the problem. If without personal service, judgments in personam obtained ex parte against non-resident and absent parties upon mere publication of process, which in the great majority of cases would never be seen by the parties interested, could be upheld and enforced. They would be the constant instruments of fraud and oppression judgments for all sorts of claims upon contracts and towards real or pretended would thus be obtained, under which property could be seized when the evidence of the transactions upon which they were founded, if they ever had any existence, had perished. Substituted, is that how you say it? It doesn't have another meaning. Oh, in chemistry it does. Substitute, okay. Substituted service by publication or any other authorized form may be sufficient to inform parties of the object of proceedings taken where property is once brought under the control of the court by seizure or some equivalent act. The law assumes that property is always in the possession of its owner in person or by agent, and it proceeds upon the theory that its seizure will inform him not only that it is taken into the custody of the court, but that he must look to any proceedings authorized by law upon such seizure for its condemnation itself. Such service may be sufficient in cases where the object of the action is to reach and dispose of property in the state or in some other interest therein by enforcing a contract or a lien respecting the same, or to partition it among different owners, or when the public is a party to condemn and appropriated for public use. In other words, such service may answer all actions which are substantially proceedings in rem. But where the entire object of the action is to determine the personal rights and obligations of the defendant, that is where the suit is merely in personam. Constructive service in this form upon a non-resident is ineffectual for any purpose. Process from the tribunals of one state cannot run into another state. And summon parties there domicile to leave its territories and respond to proceedings against them. Publication of process or notice within the state where the tribunal sits cannot create any greater obligation upon non-residents to appear. All right, let's see. Publication of process or notice within the state where the tribunal sits cannot create any greater obligation upon the non-resident to appear. Process sent to him out of the state and process published within it are equally unavailing in proceedings to establish his personal liability. The want of authority of the tribunals, the, I'm sorry, of authority of the tribunals of the state to adjudicate upon the obligations of non-residents where they have no property within its limits is not denied by the court, but the position is assumed that where they have property within the state, it is immaterial whether the property is in the first instance brought under the control of the court by attachment or some other equivalent act, and afterwards applied by its judgment to the satisfaction of demands against its owner, or such demands be first established in a personal action, and the property of a non-resident be afterwards seized and sold at auction. But the answer to this position has already been given in the statement that the jurisdiction of the court to inquire into and determine his obligations at all is only incidental to the jurisdiction over the property. Its jurisdiction is that respect cannot be made to depend upon facts to be ascertained after it has tried the cause and rendered the judgment. If the judgment be previously void, it will not become valid by the subsequent discovery of property of the defendant or by his subsequent acquisition of it. The judgment, if void when rendered, will always remain void. It cannot occupy the doubtful position of being valid if property be found, and void if there be none. Even if the position assumed were confined to cases where the non-resident defendant possessed property in the state at the commencement of the action, it would still make the validity of the proceedings and judgment depend upon the question whether before the levy of the execution, the defendant had or had not disposed of the property. If before the levy, the property should be sold, then according to this position, the judgment would not be binding. The doctrine will introduce a new element of uncertainty in judicial proceedings. The contrary is the law. The validity of every judgment depends upon the jurisdiction of the court before it is rendered, not upon what may occur subsequently. The force and effective judgments rendered against non-residents without personal service or process upon them, or their voluntary presence, has been subject to frequent considerations in the court of the United States and of several other states, and attempts have been made to enforce such judgment in states other than those in which they were rendered under the provision of the Constitution requiring full faith and credit shall be given in each state to the Public Act records and judicial proceedings of every other state, and the Act of Congress providing for the mode of authenticating such fact records and proceedings, and declaring that when thus authenticated, they shall have such faith and credit given to them in every court within the United States as they have by law or usage in the courts of the state from which they shall be taken. In the earlier cases, it was supposed that the federal statute concerning full faith and credit gave to all judgments the same effect of other states which they had by law in the state where rendered. But this view was afterwards qualified so as to make the act applicable. Only when the court rendering the judgment has jurisdiction of the parties and of the subject matter, and not to preclude an inquiry into the jurisdiction of the court in which the judgment was rendered, or the right of the state itself to exercise authority over the person or the subject matter. Since the adoption of the 14th Amendment in the federal Constitution, the validity of such judgments may be directly questioned and their enforcement in the state resisted on the ground that proceedings in the court of justice to determine the personal rights and obligations of parties over whom the court had no jurisdiction do not constitute due process of law. Whatever difficulty may be experienced and given to those terms of definition, which will embrace every permissible exertion of power affecting private rights and exclude such as is forbidden, there can be no doubt of their meaning when applied to judicial proceedings. They then mean a course of legal proceedings according to those rules and principles which have been established in our system of jurisprudence for the protection and enforcement of private rights. To give such proceedings any validity, there must be a tribunal competent by its constitution, that is, by the law of its creation, to pass upon the subject matter of the suit. If that involves merely a determination of the personal liability of the defendant, he must be brought within his jurisdiction by service of process within the state or by his voluntary appearance. So if it involves merely a determination of personal liability, so if he is served within the state or he voluntarily appears, fine. But if not, except in cases affecting the personal status of the plaintiff, and cases in which that mode of service may be considered to have been assented to in advance, as hereinafter mentioned, the substituted service of process by publication allowed by the law of Oregon and by similar laws in other states where actions are brought against non-residents is effectual only when in connection with process in connection with process against the person for commencing the action, property in the state is brought under the control of the court and subject to its disposition by process adapted to that purpose, or when the judgment is sought as a means of reaching such property or affecting some interest therein. In other words, where the action is in the nature of the proceeding in rem. So the only time that you can it has to be in rem in order for you to just be able to publish it in a legal publication and feel like that's proper notice. It follows from the views expressed that the personal judgment recovered in the state court of Oregon against the plaintiff herein, then a non-resident of the state was without any validity and did not authorize a sale of the property in controversy. To prevent any misapplication of the views expressed in this opinion, it is proper to observe that we do not mean to assert by anything we have said that a state may not authorize proceedings in which the status of one of its citizens toward a non-resident, which would be binding within the state, though made without service of process or personal notice to the non-resident. The jurisdiction which every state possesses to determine the civil status and capacities of its inhabitants involves authority to prescribe the conditions on which the proceedings affecting them may be commenced and carried out within its territory. The state, for example, has absolute right to prescribe the conditions upon which the marriage relation between its citizens shall be created and the causes for which it may be dissolved. One of the parties guilty of acts by which, by the law of the state, a dissolution may be granted, may have removed to a state where no dissolution is permitted. The complaining party would therefore fail if a divorce were sought in the state of the defendant, and if application could not be made to the tribunals of the complainant's domicile in such case, and proceedings be there instituted without personal service of process or personal notice to the offering party, the injured citizen would be without redress. The state has absolute power to prescribe the conditions upon which marriage relations between its own citizens shall be created and the causes for which they will be dissolved. All right. So one of the parties guilty of acts for which, by the law of the state, a dissolution may be granted, may be removed to a state where no dissolution is permitted. The complaining party would, therefore, fail if a divorce were sought in a state if a divorce were sought in the state of the defendant, and if application could not be made to the tribunals of the complainant's domicile in such case, and proceedings be there instituted without personal service of process or personal notice to the offending party, the injured citizen would be without redress. I need to read that again. One of the parties guilty of acts for which, by the law of the state, a dissolution may be granted, may be removed to a state where no dissolution is permitted. So one of the parties that's guilty of acts for which the one state allows for dissolution may be granted, may be removed to a state where no dissolution is permitted. The complaining party would therefore fail if the divorce were sought in the state of the defendant, right? Because neither do we mean to assert that a state may not require a non-resident entering into a partnership or association within its limits or making contracts enforceable there to appoint an agent or representative in the state to receive service of process and notice and legal proceedings instituted with respect to such partnership, association, or contracts, or to designate a place where such service may be made and notice given and provide upon their failure to make such appointment or to designate such a place that service may be made upon public officer designated for that purpose, or in some other prescribed way, and that judgments rendered upon such service may not be binding upon the non-resident. Okay, and that judgments rendered upon such service may not be binding upon the non-residents, both within and without the state. As was said by the Court of Exchequer in Valley v. Dumergue for Exchange 290, it is contrary to natural justice that a man who has agreed to receive a particular mode of notification in a legal proceeding should not be bound by a judgment in which that particular mode of notification has been followed, even though he may not have actual notice of them. Nor do we doubt that a state, on creating corporations or other institutions for, I don't know how to pronounce it, pecuniary or charitable purposes, may provide a mode for which their conduct may be investigated, their obligations enforced, or their charges revoked, which shall require other than personal service upon officers and members. Parties becoming members of such corporations or institutions will hold their interests subject to the conditions prescribed by law. P-E-C-U-N-I-A-R-Y. P-E-C-U-N-I-A-R-Y. Pecuniary, relating to consistency of money. Okay. So this is if you make a business, right? So if you make a business or corporation or partnership or association within the limits of a state, then you appoint an agent or representative in the state to receive service process, notice of legal proceedings. All right, so that's why you need a registered agent instituted with respect to such a partnership, okay? Or a designated place which such service may be made and notice provide upon their failure to make such appointment to designate such a place that service may be made upon a public officer designated for that purpose or in some other prescribed way, and the judgments rendered upon such service may not be binding upon the non-residents both within or without of the state. Okay, so may not be binding, but they may be binding. So this person has agreed to receive a particular mode of notification of legal proceedings should be bound by the judgment in which a particular mode of notification has been followed, even though he may not have actual notice of them. So you agree to be notified in this way. So even if you don't have actual notice, you're still bound by it because you agreed to be notified in this way. In the present case, there is no feature of this kind and consequently no consideration of what would be the effect of such legislation in enforcing the contract of a non-resident can arise. The question here respects only the validity of a money judgment rendered in the state and the action upon a simple contract against the resident of another without service of process upon him or his appearance therein. Judgment affirmed. Notes and questions. Understanding Pennoyer states and independent sovereigns. Pennoyer draws heavily on international law concepts that were prevalent at the time, especially the notion that courts of one nation could not typically exercise jurisdiction over people or property located in another country. Analogously, American judges believe that they should refrain from exercising jurisdiction over people or property located in another state. For example, according to this logic, an Oregon court could not exercise jurisdiction over people or property located in California. The court put it this way: no state can exercise direct jurisdiction or authority over persons or property without outside of its territory. Uh, the several states are of equal dignity and authority, and the independence of one implies the exclusion of power from all others. And so it is laid down by jurists as an elementary principle that the laws of one state have no operation outside of its territory except so far as allowed by comity, and that no tribunal established by it can extend its process beyond that territory so as to subject either person or property to its decision. The Pennoyer problem. In Pennoyer, the Oregon State Court asserted jurisdiction over Neff's Oregon property. So jurisdiction appears to have been consistent with the passage quoted before. What went wrong in Pennoyer, Mitchell sued Neff in Oregon State Court to recover fees for work that Mitchell had performed for Neff in Oregon. After Neff defaulted, Mitchell asked the court to order the sale of Neff's Oregon real estate in order to satisfy the default judgment. Why did the Supreme Court conclude that the Oregon State could not have jurisdiction in the order sale of Mitchell's Oregon property? Neff was not notified in person about the pending lawsuit. Neff was not within the state at the time the suit began. A and B both had to be satisfied and were not satisfied in the case. The court failed to attach Neff's property before it exercised jurisdiction to resolve Mitchell's claim. D. Okay, A. A is incorrect. Although the court required in-person notice to establish in-person jurisdiction, the court did not require such notice for in rem jurisdiction. Indeed, at the time of Pennoyer, notice by publication or posting was considered to be sufficient for in rem actions. Constitutional status have changed considerably in this regard since Pennoyer was decided, as you will learn in later chapters. B is not right either, because in rem jurisdiction is based on the presence of the property in the forum state, not the presence of the defendant. If the land was in Oregon, the court could assert jurisdiction over it, whether Neff was present in Oregon or not, because neither A and B are required. C is also wrong. The real problem with the Mitchell judgment was that he did not provide the court with any basis for jurisdiction before the court purported to exercise it. Mitchell filed a lawsuit and got a default judgment, but neither Neff nor his property was before the court. You should have focused on this passage in Pennoyer. The jurisdiction of the court to inquire into and determine Neff's obligation at all is only incidental to its jurisdiction over the property. Its jurisdiction in that respect cannot be made to depend upon facts to be ascertained after it has tried the cause and rendered the judgment. If the judgment be previously void, it would not become valid by the subsequent discovery of property of the defendant or by his subsequent acquisition of it. The judgment, if void when rendered, will always remain void. It cannot occupy the doubtful position of being valid if property be found, and void if there be none. Thus, to assert in rem jurisdiction under the Pennoyer framework, a court had to assert authority over the property through attachment before exercising jurisdiction, not after. In this case, when Oregon State Court entered judgment against Neff, the court did not have control over Neff's property. Seizing the property later through post-judgment attachment did not validate the judgment that had been rendered before the court had obtained jurisdiction. For this reason, D is the best answer. Before a court can exercise interim jurisdiction, it must first attach the defendant's property. That did not happen here. The distinction between notice and personal jurisdiction. Pennoyer's discussion of notice and personal jurisdiction can be confusing. Certainly, fairness requires that defendants receive adequate notice that a lawsuit has been filed against them, but fairness also requires that the plaintiff's claim against the defendant have an appropriate connection to the state where the lawsuit was filed. That is, the court must also have jurisdiction over the defendant or the defendant's property. Pennoyer does not clearly explain this distinction between notice and jurisdiction because at the time there was little need to do so. Under the Pennoyer framework, by serving the defendant with process within the forum state and state service, the requirements of jurisdiction and notice were satisfied simultaneously. But in subsequent cases that you will soon read, the court developed new ways of establishing impersonal jurisdiction, making it necessary to clarify this jurisdiction between notice and personal jurisdiction. The following two questions illustrate differences between notice and personal jurisdiction. Improper jurisdiction / proper notice. Imagine that shortly after Pennoyer was decided, Paul sued Dora in Massachusetts State Court and alleged that Dora breached a contract. Dora lived in Connecticut. So Paul hired a process server who located Dora in Connecticut and personally handed her the complaint and summons. Would the Massachusetts State Court have the personal jurisdiction over Dora using the standards set out for Pennoyer? No, because she was served in Connecticut. No, in this case, the defendant received notice of the pending lawsuit in the manner clearly likely to inform her that she had been sued. As a result, notice is proper. But under Pennoyer, personal service of process, proper notice does not suffice to establish personal jurisdiction. A court only has jurisdiction over persons and property located within its territory, not outside of it. The Pennoyer case puts it this way. Process from the tribunals in one state cannot run into another state and summon parties their domicile to leave its territory and respond to proceedings against them. Publication of process or notice within the state where the tribunal sits cannot create any greater obligation upon the non-resident to appear. Process sent to him out of state and process published within it are equally unavailing in proceedings to establish personal ability. So you can do in-state and put it in your local legal news, or you could go to her state and you can give her proper notice, but that still doesn't mean the court has jurisdiction. Thus, the problem in Dora's case was that she was outside of the state when she was served. Clear notice of the suit was not enough. Recent cases have established several bases beside physical presence in the state to support personal jurisdiction over out-of-state defendants like Dora. But a court using only the logic of Pennoyer could not force such a defendant to cross state lines to litigate a case. So here's the notice to Neff. Here's the notice that Mitchell's law firm published in the Pacific Christian Advocate of J.H. Mitchell's lawsuit against Mark Neff for $253.14. The suit appeared for 6 weeks. There is no evidence that Neff had learned of the suit before the notice. So this is 1865. How much is $253.14? How much is $253.14 from 1865 worth today? No. Okay, so it's $4,366.25 today is what you would be owed. And the land, he sold it for $15,000. Wow, that's $258,725.15. So he had a $4,000 bill in today's dollars and he got $258,000 for it. All right, improper notice. Assume now that Dora lived in Massachusetts and Paul's process service nailed a copy of the complaint and summons to the front door of Dora's house. Dora then got the papers when she returned home that day. Would the Massachusetts court have the authority to require Dora to appear? It depends. Unlike the previous example, Dora is now within the Massachusetts court's territory, so personal jurisdiction is clearly available, but whether posting the complaint and summons on the house constituted proper notice is another issue. At the time of Pennoyer, the appropriateness of a notice by posting depended on whether the plaintiff sought in personam or interim jurisdiction. In personal jurisdiction usually required notice by personal service, but notification of the lawsuit by publication, as in Pennoyer, or by posting, as in this case, was often sufficient in interim actions. So if Paul was seeking interim jurisdiction, the notice he offered would be sufficient at the time of Pennoyer. As explained later, the notice requirements for in-person and interim actions have changed since then. But if Paul were seeking to establish in-person jurisdiction after Pennoyer, posting the complaint and summons at the house was probably inadequate notice, as the court explained in Pennoyer. If without personal service, judgments in personam could be held and enforced, they would be constant instruments of fraud and oppression. The rigid requirement of personal service for in-person jurisdiction is rooted in early English practice. Traditionally, the court would direct the sheriff to arrest the defendant through a court order known as capias ad respondum and put the defendant into the debtor's prison unless the defendant posted bail. Fortunately, this draconian practice has been replaced by a symbolic seizure of the person through service of process. But the basic concept is still there. A court has to acquire power over the defendant personally in personam jurisdiction by asserting the court's authority over her. The control now occurs symbolically through service rather than arrest, but it is still necessary before a court can enter a judgment against the defendant personally. Advising plaintiffs after Pennoyer. A key holding of Pennoyer that a court has jurisdiction over people or things within the court's territory was conceptually tidy, but it had impractical consequences. Suppose, for example, Danny traveled to Oregon to hire a doctor, Potter, and incur medical bills there arising from Potter's services. Danny then moved to California and ignored Potter's bills. How would Potter go about asserting his claim for unpaid bills? If you were Potter's lawyer at the time of Pennoyer, what would you have advised Potter to do to collect? The easiest approach would have been to sue Danny in Oregon to get an in-person jurisdiction there. But to do that, Potter would have to arrange to serve Danny with process while Danny was present in Oregon. Potter's process service could have waited for Danny to return to the state from California, but Potter could not have been sure Danny would ever do so. Accordingly, any effort to get an impersonal judgment in Oregon would have been unlikely to succeed. Under the logic of Pennoyer, Potter would have had two options. First, Potter could have sued Danny in Oregon and attached any property that Danny owned in the state. Assuming the attachment took place at the appropriate time, the court would have the authority to order the sale of the attached property. One problem is that defendants like Danny usually do not leave significant property behind when they leave a state. Moreover, even if a party leaves a property in the forum state, a plaintiff can only obtain full relief if the property is worth more than the amount of the judgment. A court within rim jurisdiction only has the authority to dispose of the attached property, so any damages in excess of the property's value would not be conducted. A court within only has the authority to dispose of the attached property, so any damages in excess of the property's values could not be collected. Okay. Another option would have been to sue Danny in California and serve him with process there. That way, the California court would have impersonal jurisdiction over Danny. If Potter obtained a judgment and Danny failed to pay it, the California court could have ordered the sale of Danny's California assets to satisfy the claim. Moreover, under the full faith and credit clause, Potter could have taken the in-personam judgment into any other state and enforced the judgment in states where Danny had property. Unfortunately, you would have to advise Potter that pursuing claims in other states was and still is a more expensive option. Understandably, Potter would not like this advice. Indeed, it sounds quite unfair to require Potter to litigate in California over Danny's allegedly wrong conduct occurred in Oregon and injured Potter in Oregon. This basic problem helps explain why the court subsequently developed a different approach to personal jurisdiction in International Shoe v. Washington, a case that appears later in the chapter. Let's just finish this. And intentional exception status determination. Sometimes an opinion is notable for what it does not include. In Pennoyer, the court went out of its way to say that its decision did not impact how courts should resolve status determinations. For example, when a court grants a divorce, it is essentially granting a status change to the married couple. What Pennoyer said, and what is still true today, is that courts can have jurisdiction to grant status changes such as divorces, even though one spouse cannot be found or served with process, because the marital status is viewed as a rest, a type of property right. A court can typically dissolve the marriage if either of the spouses appears in court and is domiciled in that jurisdiction. For example, at one time, Nevada considered a spouse to be domiciled in the state after a very short period of residence. As a result, Las Vegas developed a reputation for granting quick divorces. This exception, however, does not apply if one of the spouses is seeking financial support, alimony payments from the out-of-state spouse. In such a case, the court is being asked to do more than grant a status change. It is being asked to require the out-of-state spouse to incur a financial obligation. A court needs in-person jurisdiction over a spouse to impose such an obligation. Prelude to a problem consent. Another exclusion appears in the next to last paragraph of the opinion. The court explained that a state could require out-of-state businesses to appoint in-state agents for service of process as a condition for conducting certain types of business in the state. If a case arose, plaintiffs could obtain personal jurisdiction over the corporation by serving the summons and complaint on the in-state agent. The court also recognized that individuals could consent to a court's exercise of jurisdiction over them, even if they would otherwise not be subject to jurisdiction. Another exclusion appears in the next to last paragraph of the opinion. The court explained that a state could require an out-of-state business to appoint in-state agents for service of process condition for conducting certain types of business in state. If the case arose, plaintiffs could obtain personal jurisdiction of the corporation by serving the summons and complaint an in-state agent. Okay. Pennoyer's P, Oregon historical image. Sylvester Pennoyer, picture here, purchased Marcus Neff's Oregon homestead on the west bank of the Willamette River in Portland under a sheriff's deed. He lived in the property for 8 years but faced eviction after the Supreme Court's decision in Pennoyer V Neff. Although he went on to become governor of Oregon, Pennoyer remained bitter about the legal system and lambasted the Pennoyer V Neff decision in his inaugural address. Later, he urged impeachment of the entire Supreme Court. The fascinating background of this case is told in Professor Wendy Perdue's classic article, Sin, Scandal, and Substantive Due Process, Personal Jurisdiction, and Pennoyer Reconsidered. And that is all we're going to read for today. Thank you for joining in for Legally Narrate or Legally Raven here, whatever we're going to call ourselves. We don't yet know. And we will pick up here tomorrow where we discuss social change and doctrinal rigidity, problems with the Pennoyer doctrine. Thank you. Have a good day. Bye-bye.